The tests and considerations to be applied by the court while exercising the powers under sections 227 and 228 of the Code fell for consideration in the case of State of Bihar versus Ramesh Singh, and it was held that the standard of test and judgment which is to be finally applied before recording a finding regarding the guilt or otherwise of the accused is not exactly to be applied at the stage of deciding the matter under section 227 or 228, and at that stage, the court is not to see whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in his conviction. While considering the tests to be applied by the court for the purposes of discharge, it was held that reading sections 227 and 228 together in juxtaposition, it would be clear that at the initial stage of the trial, the truth, veracity and effect of evidence, which the prosecutor proposes to adduce, are not to be meticulously judged, and the standard of test and judgment which is to be finally applied before recording a finding regarding guilt or otherwise of the accused is not required to be applied at this stage. The test would be whether there is sufficient ground for proceeding and or whether there is sufficient ground for conviction. Under Section 226 of the Code, while opening the case for the prosecution, the prosecutor has got to describe the charge against the accused and state by what evidence he proposes to prove the guilt of the accused. Thereafter comes at the initial stage the duty of the court to consider the record of the case and the documents submitted therewith, and to hear the submissions of the accused and the prosecution in that behalf. The judge has to pass thereafter an order either under Section 227 or Section 228 of the Code. If the judge consider that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing, as enjoined by Section 227. If, on the other hand, the judge is of opinion that there is ground for presuming that the accused has committed an offense which is exclusively triable by the court, he shall frame in writing a charge against the accused, as provided in Section 228. Reading the two provisions together in juxtaposition, as they have got to be, it would be clear that at the beginning and the initial stage of the trial the truth, veracity and effect of the evidence which the prosecutor proposes to adduce are not to be meticulously judged, nor is any weight to be attached to the probable defense of the accused. It is not obligatory for the judge at that stage of the trial to consider in any detail and weigh in a sensitive balance whether the facts, if proved, would be incompatible with the innocence of the accused or not. Don't forget to like, comment, and subscribe to our channel for more informative videos like this one. Hit that notification bell to stay updated with the latest tips and tricks to succeed in your exams. Stay connected with us on social media For additional resources and updates, join our Telegram group https://t.me/Lakshyasteno. For any query, WhatsApp on 99915607999.